Well, good evening, everybody. Good evening. It is the first Thursday of the month, and I am Carmella George. I'm happy to be with you. How are y'all doing tonight? Tell me where you're from. Tell me where you're from. I took a little break last month, so I'm so glad to be back. Grateful to be with you all again. Let's see who we got in the room tonight. Okay, I see Savannah GA. I was just there last week, I think. My friends from North Carolina. Okay, we got Oklahoma in the house on YouTube. Missouri, Illinois, Maysville, South Carolina. Never heard of that. But I was just in South Carolina last week. Let's see. This is always interesting to me. Boston in the house. The Celtics are in the playoffs, aren't they? In the championship. San Francisco, go Warriors. I think I'm rooting for the Eastern Conference, to be honest with you. But I haven't watched the playoffs at all, not a single minute. So I don't really know who's better and who's worse. I'm just going to go for the East Coast because I'm from the East Coast. Maryland. We got Maryland in the house. Another from Hanover, Maryland. Eastern NC, my home. Welcome. Moultrie, Georgia. Dale City, Virginia. Fort Worth, Texas. All over the country tonight. Welcome. I'm so glad to be back with you all. I'm so glad to be here. So happy to help and answer your questions. I am Carmella George. For those of you that don't know, I'm a VA Accredited Claims Agent. That simply means I'm individually accredited by the VA to present, prepare, and prosecute claims. I basically, more simply, I do claims professionally. I'm not a licensed attorney. I'm not a veteran service officer. But again, what is called a VA claims agent. It's much like what the DAV and VFW American Legion do, except those folks are accredited as a group, and I'm accredited as an individual. So I love what I do. This is my passion. I love helping veterans, and I'm so happy to take your questions. I'm also very excited tonight to have a special guest with us. She is now what I consider a friend, and she has been doing this for quite some time too. Hey. And so I'm happy to welcome VA Accredited Attorney Tamesha Larbi to the stage. Hey, Tamesha.
Hi there. How are you?
I'm great. How are you?
I'm hanging in there. Just hanging in there.
That's all we can do, right?
Right. These past couple of weeks have been a little rough, a little jarring for us all. So I'm hanging in there, but always glad to spend time with you. We've been talking about doing this for a while, and so glad that we actually put it on the calendar months ago. Because I think if we had not made that commitment, this probably wouldn't have happened.
Right. So I'm so happy that you're here, Tamesha. And go ahead and tell our viewers a little bit about yourself.
So I'm Tamesha Larbi. I am an attorney. I'm an attorney accredited by the Department of Veterans Affairs to represent veterans or their family members in conjunction with claims, but my office really focuses on representation for appeals. I'm also admitted to practice before the U.S. Court of Appeals for Veterans Claims, as well as the Court of Appeals for the Federal Circuit. I'm a retired JAG officer. I got my introduction to this work during an assignment that I had while working for U.S. Army Medical Command as a physical evaluation board attorney. Those attorneys represent service members, or in my case, soldiers, who have been recommended for medical discharges. And my role at the time was to kind of carry out the wishes of the soldiers, because sometimes they would have medical conditions or disabilities, but that did not make them unfit for continued military service, and they wanted to stay in. You had others who had disabilities that they felt made them unfit, and they wanted to be medically separated, or most often someone to advocate for them for medical retirement. So I have really enjoyed kind of using all those skills that I picked up over a 22-year military service history, I did not start out as an attorney. I started out as an 88 Mike, which is a truck driver. Then I became a 27 Delta, became a paralegal. And then when I got admitted to the bar, then I applied for a direct commission and assessed into the Army as a JAG officer. So post-retirement, I spend my time in beautiful Maryland suburbs. I see a couple of people here that are not too far away, but I have a solo law practice that focuses solely on helping veterans obtain long overdue benefits. So I say veterans, but also their families, because I have a lot of surviving spouses and or adult children of veterans who are pursuing benefits in a variety of different ways. And they've been at it for a really long time. So I kind of like to say that's a little bit of my niche, is working with people who've been in the claims and appeals process for a considerable time, and they're looking for an advocate to help bring about some resolution to their appeals so they can go on and live their life without having to go back and forth with the VA about whether or not they're entitled to benefits.
Right. So, Tamesha, you've been out this for a good while, and Tamesha is a superstar. So I'm proud to be associated with her, proud to know her, and she has a wonderful track record. For those of you who don't know, she just won an award at the latest NOVA conference that was held in March?
Yeah, it was in March. Yeah,
and she won an award for her practice and what she's been doing in the VA space, veterans law space, and that was exciting. But a lot of Tamesha's practice, she practices at the board, like she said, mainly handles appeals and court, takes things to the court level, Court of Veterans Appeals for Veterans Claims, United States Court. And so I want her to talk a little bit about her work at the court and what that level of appeal entails. Well, from what I see regularly, and I, advise thousands of vets at this point, represented, probably a very good number of vets, significant number of veterans. And sometimes things just stop after the BVA. So I wanted Tamesha to take just a couple minutes before we get into answering questions, which we are going to do tonight, and just talk about what going to the Court of Veterans Appeals entails if you get denied at the BVA, and what that process is sort of like. So you all can get familiar with it.
Okay, so I'm going to speak in kind of broad generalities. And I do agree with Carmella that a lot of times the veterans who've been at it for a while, they think the board is their last stop, but there really is an option beyond the board to appeal to get a decision, usually a denial, or less than favorable, like if it's an effective date issue or an evaluation issue, those kind of things. But to go to a much higher authority to see whether or not the board's decision was correct. There's some caveats and there's context to that. The court doesn't decide anything in the first instance. That means like they're not the ones who make a decision in the first time, but rather what the court is doing is looking at the work that happened at the board to ensure that the board reached the right conclusion based upon the full record. And that kind of can go a couple of different ways. I saw someone write a question earlier that basically said something like, I keep getting denied because they're saying there's no record of this incident happening while I'm in service. So when something like that gets appealed to the court, we're not really asking the court to determine whether or not the thing did or did not happen while in service. Sometimes we are. But the thing that we're asking is whether or not the board ensured that the secretary complied with their duty to assist the veteran in obtaining records to support their claim. So from my perspective, when I am working on a case, a lot of times when I'm hearing what the veteran's saying, they're saying like, this happened in service. I was hospitalized at Womack Hospital at, Fort Bragg, and I was there for 4 days and da 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 da. And I look at what's in their claims file. There are no medical records there. There are no service records there at all. They're supposed to be there, but they're not there. And so that is a duty to assist error that again can change the trajectory of the case, because what the board did was they made a decision about whether or not something had an onset in service, and but they didn't have all the records. They didn't ensure that the secretary complied with their duty to assist. And there's some nuances to that, but that's just kind of a general thing. So that's one of the first things that the court, you know, in terms of like what the court does and what they're looking at. Separate and apart from that, you know, the court also has some oversight, and I'm using oversight loosely, but one of the things that the court does is to see whether or not the board applied the law correctly. That is a common mistake that happens. We see it happen at the RO level. It kind of gets copied and pasted in some cases at the board level, and then the veteran kind of throws up their hands thinking that there's nothing that they can do about it. And I'll give you a good example of that. So the board, and same example, the regional office said something like, hey, there is no record that you injured your back while in service. So therefore it must not have happened. The board comes along, kind of rubber stamps that thing. And then it gets to the court and we say, hey, wait a second. Absence of evidence cannot be used as evidence against the claim. And so that the law was not applied correctly in that instance. There's some other things like with congenital disorders. You know, back in the 70s and 80s, we see a lot of cases where someone was denied benefits because their claim condition was considered to be a congenital disease. And they were like, you can't get service connection for this. Well, that's not what the law actually says. It says something different. So when we take the cases up to the court, when we make the decision to appeal to the court, it has some great implications when we are successful in terms of changing or kind of altering the adjudication path, if you will, for what is to happen next. Sometimes the court, if the board made a decision in the first instance, the court will come and say whether or not the decision they made was correct. More commonly, a lot of the cases get remanded back to the board for the board to re-adjudicate the claim. And so going to the court, what that gives the veteran or their surviving spouse or heirs is like some instructions like, hey, board, you made a mistake when you did this. You need to re-adjudicate this claim. And sometimes there's some other little ancillary instructions in there. Like, hey, you need to go look for this service member's records. We've got proof that we know that there's some records out there. The person identified who has these records, you didn't go get them. Or, hey, board, you need to apply the law correctly, and this is what the law says. You need to do that. So a lot of times those remands can be very helpful to finally getting the claim and appeal off this denial hamster wheel, because now we've got a better set of instructions to go by. And even still, when the board doesn't follow the directions, because that does happen sometimes, we can then go back to the court and say, hey, the board failed to comply with the remand order. You told the board to do this, 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 and this, and they did that and thus and though. So we have some, it gives us some leverage to course correct. And that's kind of what how I like to say it and how I like to look at it is there's some course correction that can happen when you appeal to the court. Sometimes the court doesn't get it right either. And so even if you appeal to CAVIC or the Court of Appeals for Veterans Claims, you can still take it up one notch higher and go to the Court of Appeals for the Federal Circuit. Now, in that court, they do not review factual determinations of CAVIC. They only review legal determinations. And that means that, just as a matter of strategy, you've got to go really strong in your CAVIC appeal so that you have preserved the grounds in which you would appeal even higher. But there's some great benefits to that. And I just want to kind of add this in. I know like when we start talking lawyers, court, the immediate question, like the very first question that comes out of anybody's mouth is, how much does this cost me? Like how much money are we talking about? And one of the reasons I believe a lot of veterans think that they have no options beyond the board is that it's not economically advantageous to hire an attorney to go to the court. Well, there are a couple of options out there. Of course, the veteran can represent themselves pro se. It's not always advisable to do that because even though you're pro se, the court has some rules that it follows. It has some relaxed standards. But in addition to that, there are some organizations and some attorneys who can step in and be pro bono attorneys for veterans who don't have representation. That is an option that is available. And that's actually how I got my start in doing this work post-retirement. The other option is if you retain an attorney for representation at the court, you can look in the court's directory. They keep a public directory. Some attorneys' names are there, some are not. But most of the time, the financial arrangement is that the representation will be provided pro bono, provided that the veteran or their family member has no objection to or would not oppose an attorney application for attorney's fees under the Equal Access to Justice Fund. We call it EJA fees. Equal Access to Justice Act, EJA fees. And basically what it is that if the case is successful, meaning we've got a verdict that is in the veteran's favor, meaning we're getting a remand, we're getting a decision, or something else in between that is favorable, we are the prevailing party, the attorney can petition the court for attorney's fees on behalf of the veteran, and the secretary can agree or oppose or suggest a reduction. That petition goes to the court reviews it, they approve it or deny it or something else. But basically that is how many attorneys are paid for the work in representing veterans at the court. So that kind of opens up access to people who need to appeal beyond the board, who want to try to get their claim and appeal favorably decided once and for all. And so that's what the court, very summary fashion, kind of gives our veterans and their families as an option for further appellate review.
Oh, awesome. And then, Tamesha, there's just one step above the federal court, which is the highest level you can go to with a veteran's claim or appeal is the United States Supreme Court. It's got to be mentioned, especially in the context of today and the time we're in now, because there's two, maybe three very significant cases before the court right now, the United States Supreme Court, that will have tremendous effects on the veterans law world, which we're expecting decisions on soon. I know all the details of them off the top of my head. I know one is concerning what a clear and unmistakable error is, and the other one is concerning equitable tolling, which is, whether the date can be held can you give a little simple explanation on equitable tolling?
Whoa, you're putting me on the spot. You should have sent that question over so I could give like a really nice and polished one. But I'm going to give you like simple terms. Yeah. But basically, equitable, meaning that the rule is this, but there are some equitable reason why we should not follow the rule and instead consider your filing as timely. And I'll give you an example. I just had this happen in a case recently. So last year, for those who may or may not know, there was a huge service interruption with the VA's mail system starting about July of 2021. And so there was also a separate and a different issue where people like myself and Carmella, the VA would not necessarily update our business addresses in a timely fashion or in a consistent fashion. So for me, a lot of my mail, my business mail, was going to the wrong address, right? And I had no way of knowing that. At all. And so by the time some things got sorted out, a client calls me and says, "Hey, I just got this mail from like 3 months ago." But by the time they called me, their time to appeal to CAVIC, the 120 days, had expired. So I went ahead and I filed the appeal anyway. And I requested, it was a very informal fashion, but I requested what's called equitable tolling, meaning that we weren't within the 120 days, but there were some other things that happened in equity. You should consider this thing as timely filed. That is the general gist of equitable tolling, but there's a lot of other stuff that comes into play when we're talking about equitable tolling with the VA case. And while I'm not 100% immersed in all the facts of the case that you're referring to, a lot of times equitable tolling could be, I have another case that I'm working on where it's a DIC claim where the VA, not the military, not the DOD, but the VA lost the veteran's claims folder. We have no idea what's in the claims folder. It's been missing for 30 years. But guess what? We need what's in that claims folder to pick up with a claim today. So if there are no other grounds in which I can go back in time to get like a revision or reconsideration or something, I need to have like equitable tolling, because for 30 years, the VA hasn't been able to find this veteran. The veteran is deceased, but hasn't been able to find their service records. Other things that should warrant equitable tolling would be things like people who worked in classified jobs who may or may not be able to discuss things to kind of get their claims granted. Another way is like when DOD or somewhere between DOD and VA, they can't find your records. And the fact that the records have been missing or were missing, that may have caused you to miss out on filing a claim, knowing that you were eligible and some other things. So I think it's going to be very interesting to see what this court does with some of the issues as it relates to Title 38, Veterans Benefits Law, and the like.
Yes. Yes, and I believe I'm like Tamesha said, neither one of us are well versed in either of the cases before the Supreme Court right now, but because it's so significant, I believe the veteran, the basic, like essential element is that the veteran's claiming his mental health disability played a significant role in the delayed filing of his claim, and so it should be backdated. Those are, so I might not have that exactly right, but those are the basics, and what the Supreme Court decides will be far-reaching. And so a lot of people have written in support in both veterans that we discussed tonight. And it's really going to be very interesting what the high court decides. But let's jump into questions. I'm going to start with this one. It didn't come in first, but it's a really good question that follows into what Tamesha was just talking about. So I'm going to let her answer this, but this is a real good question. Let's see. Question for Larby. Can I request a jury to decide my claim?
The answer to that is no. But let me kind of give some context to my no. Okay. So who decides the claim depends upon what level your claim or appeal, where it is, like, where it is in the hierarchy. So when it's at the regional office level, you've got your raters and your rating team that will be participating in deciding your claim. When it goes to the Board of Veterans Appeal, it is usually a single veterans law judge and maybe their law clerk or the attorneys that they, and I don't want to say deciding, but it's usually authored by a single VLJ. There are some times when multiple VLJs will participate in a decision, and I don't know that off the top of my head, but I have seen it in one of the board manuals. Then when it gets to the court, if the issue is not of what we call precedential impact, meaning it's not setting a new precedent, not correcting, clarifying a previous precedent, it will be decided by a single judge. There are other times when a panel of 3 judges will assemble to decide an appeal. And then there are other times when the entire court will come together to decide your case. One of the things that is unique about the Court of Appeals for Veterans Claims is that it is not an Article 3 court like what you think about, like where you can have a jury and all those kind of things. It was established under a different constitutional provision. And with that being said, juries are not a part of that. It's just not. So think about like your tax court or bankruptcy court. Those types of courts have different authority from the Constitution. And so that's why we don't see juries at the Court of Appeals for Veterans Claims.
Good, great. That's great. I knew the answer was no, but I didn't know all the why behind it. So thank you, Tamesha. Okay, so here we go. Let's get back to the top. I just got my CMP results, which were unfavorable for sleep apnea, but I have a private nexus stating it is at least as likely as not service connected, I presume. Should the nexus hold more weight? I'm still waiting on the decision letter. Well,
okay.
Yeah,
go
ahead.
No,
there are a number of factors and variables that go into making a rating decision. At the regional office level, the discretion of what weight should be afforded to each piece of evidence lies with the rater, the person, the decision maker. It should, theoretically, the rater could look at the private nexus and say, this is more credible, this is more persuasive, it holds, it has greater value, or is done by a better qualified professional than the CMP exam. Or they could look at the CMP exam and use any of those factors or additional ones to explain that the CMP exam in their eyes holds more value. We all know that what the law says is that when evidence is sort of in an equal state or approximate balance of being equal, that the decision should go in favor of the veteran. That at the regional office level, at least, doesn't happen as much as it should in theory. It doesn't happen as much in practice as it should in theory, but that is a factor. And so, we can't necessarily say yes, they're going to consider the private nexus letter. We would have to read it and see how substantial it is, what the reason it is, see what kind of medical opinion the CMP examiner gave, whether it was in depth, whether it explained, they adequately interpreted your contention and that type of thing, and they backed it up with adequate medical literature. And there's a lot of variables at play here that the rater has to consider and come to a conclusion on. What I will tell you is that there are many times, I dare say the majority of the time, but a lot of the time, the CMP examiner, I can argue that the CMP exam results are not adequate, or they're inadequate for some reason. So I would review, if you get a denial, review those exam results closely, maybe have a professional take a look and decide your route from there. What the private nexus should do, though, is give you a fighting chance to win that claim. If it is in the preferred VA language and contains all the elements the VA likes in a medical opinion. I should take this time to say that there was a recent update to the M21-1, the Rater's Manual kind of Bible that gives some procedure on what to go by, that talks about what a valid medical opinion is. Now, this has been decided long ago by case law, and I mean, it's the kind of the law talks about what makes the opinion adequate, but case law has defined it more, and the VA finally decided to clarify it in their manual for regional office raters. So it's a little more. You should look up that section if you get denied. And many veterans out there, I'm speaking generally now to the veteran population, know what counts as a valid medical opinion, because sometimes you can argue that the medical opinion given by the VA wasn't adequate, it's inadequate. The private nexus I provided should weigh more. This is especially true if you maybe have a representative with electronic access, or you can get access to your exam report before a decision is made. And just say, the nexus opinion submitted by my private examiner should weigh more. I would write a statement and it should weigh more because blah, 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 blah. I try to be proactive, not reactive. And if I can submit something that talks about why I want the private nexus should weigh more than the CMP exam, I will do it. So, take every opportunity to argue for yourself if you're not represented. Tamesha, you want to add anything there?
Nope, nothing to add.
Awesome.
Nothing to add.
How should an appeal how should an appeal take if sent to a judge for a second review? I'm assuming you're talking about how long should an appeal take if sent to a judge for second review?
So let me just kind of talk about that. This is one of those things that I think, being a practitioner, I have a very different perspective on like what's a normal amount of time. The veterans and their family always think like, this is way too long. This is taking too long. There is, at this point in time, and I'm going to speak kind of at the administrative level, which is at the board level, there is very little predictability with time, but I want to explain why that is. And it's not due to like indifference or incompetence, but I would like for people to appreciate that sometimes a single veteran's file, one veteran, the C file that needs to be reviewed can easily be thousands of pages. Thousands. And that's a lot of information to synthesize. And by synthesize, I mean connect the dots. There's nothing that I get, and Carmella, you can chime in if you will, there's nothing that I get that has everything already pieced together in a nice, neat, orderly fashion. I'm just going to say like me, I've got to read the service records. I've got to read the past rating decisions, read the past claims. Then I got to figure out a timeline. Then I got to look at the decision. Then I got to figure out, okay, what the law is. And if we had like supercomputers that did this work for us, I think we would see things coming through like that. But there are human beings on the back end of this process. And I think that the process moves really as fast as it can move, absent some egregious mishaps that do happen in the process. So they're really, I know for myself, I've started to get better about saying that this is going to take some time if you decide to pursue this avenue, but this is the potential benefits. These are the potential not so great things that can happen if you decide to appeal to the board or to appeal to the court. Things take time. And but I do know that the longer it's like the veteran has tinkered on their case themselves, it takes longer to kind of undo 2 decades of denials. I don't know about you. Like, it's not like just quick and easy work. Like, it really does take some elbow grease to turn that ship around, versus I recently had a case a couple months ago. This person just got off active duty. That happened like, that was like the easiest case I ever had. But it was because we were not looking through we weren't looking back in time so far, and all of this person's records were electronic. So we had the benefit of, being able to move through it really quickly.
Yeah. So just what Tamesha said, it's going to take some time. The BVA is a little different than the regional offices, how they process claims, but it usually moves in order that it was received, except for cases that are advanced order docket and remands under the legacy system that come back to them. And so probably you're looking at just very generally, loose time frames, looking at least 3 months on a remand that went back, certified back to the VBA. I'm assuming this is for a legacy appeal, but if it can go if we're talking about a remand here, you could be waiting up to maybe a year and a half at this point in BVA life. But if you're talking about the BVA in general timelines, even the direct review is taking about 2 years right now if you're just submitting an appeal. So it's taking a year and a half or 2 years, where the VA has previously stated they would try to decide them in a year. That it has been their stated goal, but they've also updated a couple months ago and said they're not meeting their goals right now, timeliness goals. So there's going to be some shifts at the BVA happening soon in terms of leadership, and we might see some more hirings with this PACT Act. They're investing in the claims process. So we'll see what happens. Hopefully they find ways to clear up the timeline, but right now there's just a huge backlog. Okay. Do the VA have to send you to a CMP just to check the box on their end, because they still come back and say there is no history in the service record?
Okay, so this is the one right here. This is a question I saw earlier that I was referring to. And so this question kind of raises to like when I see this, my spidey senses go up when they're okay. Because they still come back and say there's no history in the service record. So the question is, do they have all the service records? Do they legitimately have all of your service records? And that is a very important question to pose, particularly for those who were once on active duty and then went to Reserve or National Guard or switched branches. So say, for instance, you were in the Army, then you went over to the Marine Corps, right? That is a common reason. Missing records, lack of records. It's a common reason why claims are denied. And so unless the veteran or the rater or whoever else is working on the file picks up on the fact that they don't have all the records, you're going to get that. But this also goes back to what we said earlier. Absence of evidence isn't necessarily evidence against the claim. Now, I want to talk about the first part of this question. Do they just send you to the C&P exam to check the box? Although the VA has its issues, I would also like for you to know that more people are working to help the veteran than against them. So when they're sending you for this C&P exam, or they're sending the C&P exam back, the positives of that is they're trying to help the veteran get evidence to support the claim and also prevent future appeals. Now, when you have a representative, Carmella, or like myself, that has the VBMS access or access to the VA system, we can see what's going on and we can kind of make an assessment whether or not these returns for subsequent C&P exams, whether or not those returns are really valid, or if like there's just some hamster wheel stuff going on. And a good advocate, will assert themselves to say, hey, you're sending this person back for an exam, but they didn't claim this, or there's already enough evidence, or they want to waive any future exams and would like to have their claim decided. You can do though, that's where having an advocate is really advantageous, because in the length of time that it takes for the VA to mail the veteran correspondence, I've already seen it because I see it the day it hits the system. I don't know about you, Carmella, but I'm checking for those changes in cases, and we can see now we get notifications when certain things are going out. And so you have a list of stuff that you've got to get. So that's what this question brings up. That's what, I'm not a betting person, but it sounds like there's some records missing there.
Right. And to answer the question directly, does the VA have to send you to a C&P exam just to check a box? No. If there's enough probative evidence to make a claim, it's what's called a fully developed claim, they can make a decision without an exam. So, yes. Thank you, Tamesha, for that. Mm-hmm. Okay. Here's an interesting one. Hello, everyone. Please explain the steps towards getting approved for SMCT. So this is a question that requires a complex answer and a detailed answer because it's about TBI and how you get aid and attendance for it. That's basically SMCT. Please ask me this question offline, and I'll try to point you to some direct information. But off the top of my head, you basically have to show you're not eligible for regular aid and attendance, and you have to have the TBI, and it significantly affects you. But there's some other steps and some ways to submit evidence to support that. So I want to get you the most detailed answer possible. Please get with me offline about that. Okay. How long should a claim be if sent to a judge? Part of this answer depends on what lane you chose at the BVA, whether you chose the direct docket, the evidence docket where you can submit new evidence, or the hearing lane where you have to wait for a hearing. Like I said a few minutes ago, the VA is not meeting its stated goals for timeliness. Right now, direct review with my cases, and I have a significant number of them, is running at least a year and a half, was what I'm saying. And other dockets lanes take more than that. So if you just submit it might be a while. But that's why, part of the strategy I use as a representative is try to do everything possible to win a claim at the regional office, to exhaust every single avenue before I advise that a veteran submit to the BVA at this point. Now, if the BVA was to speed up at some level, the BVA is certainly a good place to be in some circumstances. The VA is a little more lenient and they apply the law a little better than they do at the regional office to cases. And so sometimes it is more advantageous to go before the board and take your case to the BVA. But the wait time right now is a significant deterrent to doing that. And so at some levels, now the decision should be made with considering the pros and cons of doing it. It should not be entered into lightly. So, a representative can help you decide if that's the best way to go. And there are some cases that just shouldn't be tried at the regional office again. Those are specific circumstances. And, I have to advise based on the specific individual circumstances of the case. No two claims are the same in VA world, veterans law. It just, you served at different times. Even if you served the same number of days, you started on January 1st, 2020 and ended on January 1st, 2021. The facts and individual circumstances of your service, are like night and day, could be apples and oranges, could be very different. And the files within your claims file are very different. So no two benches are the same. It can take a while at the board right now, a good while. Top of the evening to you, Mr. Oh, hi, Mr. Burns. Hi, Mr. Burns. Okay. Hey, from Converse, Texas. Hey, I like my chucks. I'm putting my husband in for Tdiu. He has a rating of 70% for anxiety. Will he be called for a CMP exam? More than likely, yes. If private evidence is not submitted that, would satisfy the VA or show that he is eligible for Tdiu in the VA's preferred way of looking at it. And more than likely for Tdiu, they consider Tdiu to be a claim for increase. And there is usually an exam associated with increased claims unless there's evidence of record that would satisfy the VA. Anything to add there, Tamesha?
Nope, nothing to add there. Just make sure he shows up for the exam. If you can't attend the exam, communicate, call the VA. Just, ask them to do a report of contact and indicate that you cannot attend and you would like to reschedule because you want to go to the CMP exam. I think that's very important.
Yes. Okay. Hi. Can I file for Tdiu even if I'm 100% scheduler but not PNT? My disability causes me not to work. Okay, so this is an interesting one. I'm sure Tamesha has something to say here, but I was turning my head while I was reading it because there are a few ways you can get to 100% with the VA. And one of them is just by having enough disabilities that total 100% and you're 100% scheduler. That means that you've reached 100%, but it's not yet rated permanent and total. So one or more of the conditions you're rated for is still subject to future exam because some whoever made the decision believed that there was a future likelihood of improvement of at least one condition you're rated for. Otherwise, it would have been granted permanent and total. But it would appear to me, in my opinion, that it would be needless to take such a route because 100% scheduler is essentially a higher benefit than Tdiu. You don't have to give income. You don't have to report your income every year. There's no income requirement. Both of them, you're getting paid the same rate at Tdiu at 100%. There is no increased benefit that I can think of at the moment to be in Tdiu rather than 100% scheduler, unless that Tdiu is made permanent and total itself. That's about the only caveat. But even still, you could just ask the VA to make the 100% scheduler permanent and total. There are provisions for that in the M21 manual that tell you need to put it on a 521-6EZ, the request, and that it would be considered a request for increase. You'd probably have to go through another exam unless you submitted evidence that will satisfy the VA's opinion that there's no future likelihood of improvement, and they just rated it off the evidence. But Tamesha, what am I missing here? To me, it doesn't seem like that's a worth undertaking.
I have nothing more to add. You covered everything I would have said anyway. So,
all right. Here we go. Good evening. My migraines got service connected good, but at 0%. My Nexus and medical records say it should be rated at least 50%, but I'm assuming CMP said 0. There's a couple avenues for relief here. You could ask for a high level review and argue that the private evidence or other evidence you submitted should have led to a higher rating. That's one way to do it. The law clearly says that when there is a question of which 2 ratings should be applied, the higher rating should apply to the veteran, should be given to the veteran. So that might be one way to argue that. Higher level reviews are moving pretty swiftly these days. That's one benefit of higher level reviews, although there's a high denial rate even at that level right now. The second thing you could do is put in a supplemental claim with the DBQ. At this point, you don't need another Nexus. You've already been service connected. You don't need not connection anymore. You only need to show the severity of the condition. And so you could submit a private DBQ and if they were to grant the higher rating based off the DBQ, it should be dated because it's been continuously pursued. Assuming this has happened within the last year or so or since COVID, it should be dated back to when it happened, the higher rating. The other route you could pursue is just asking for an increase of the 0%, which is probably not advised because you wouldn't get it backdated, but it's another way to get a CMP exam if you can't get it any other way. You said my Nexus and my medical records say. A Nexus letter says it's a medical opinion, basically, that says something is service connected. A lot of times it doesn't talk about the severity of the condition. So what you want to make sure is that your Nexus had the elements that are needed that would be on a DBQ for migraines, and that's how it would get rated higher, if that makes sense. Your medical records, of course, might give the severity of your condition, and you could argue that the elements there are in written form, maybe not exact DBQ form, that show all the elements needed to meet 50% or 30% or 10%. Yeah, something higher than 0, but certainly medical records could help the situation. But your last statement is true here. A lot of times, I dare say the majority of the time, the VA just rates you based on what the CMP exam says. It kind of overlooks or doesn't review in depth the other evidence of record, VA treatment records, Nexus letters, that might not be in the exact form it needs to be, but says exactly what it needs to say for the high rating. So you have to review the evidence. You might want to get a professional to review the evidence and then make a decision from there. Tamesha?
So I'm going to kind of give a lawyerly response, which is it depends, but I'm going to tell you what it depends on. A non-compensable rating depends on whether or not there was favorable evidence that was not favorable evidence that would have supported a higher evaluation that was not taken into consideration at the time of the CMP exam. That's number one. Number two, whether or not the rater properly read the CMP exam. Because sometimes what the rating decision says may be vastly different from what the CMP examiner actually said. And the third thing is whether or not we used to say, relative equipoise, but we kind of say something a little bit different, whether there was both positive and negative evidence to support different rating levels and whatnot. And that goes to what Carmella was saying is that, when there's a question about which rating should be assigned, the higher evaluation should win. Carmella made a really interesting point, and that is getting a representative or getting your claims file or working with a representative to review your claims file to see why you actually got a non-compensable rating is really important. One thing I kind of want to insert here, but also for the group as a whole, you have to make a decision about how long will you work on something yourself. As an attorney, I I recently had a few cases at the agency level, and the complexity in the case was because the veteran kept working on the claim over and over and over and over and over again. And that just added more layers that I had to break down to get to, to turn things around. So make a decision as to how long you're going to tinker with it yourself, and whether or not you will seek out assistance from county veteran service officer, accredited claims agent, VSO, attorney to address the issue about the 0% evaluation. That's my addition.
That's a real good point. You got to decide when it's time to pass the ball. Sometimes you just need to get somebody who can look at it, who can look at the whole record really quickly and look at it in depth and, give you a professional opinion that does these things every day. Sometimes it could really turn a claim around. Tamesha's spot on about that. So last Nexus from the private doctor. He did not review my C file. I was denied. I appealed with new Nexus, having same doctor now reviewed my C file. Will this second Nexus new evidence carry a lot more weight?
So I just want to, the answer is we don't know, because the VA determines what weight gets applied. But I want to go back to the first part of your question, and that is that it was denied because the private doctor did not review your claims file. And there's some case law that says that, hey, having not reviewed a claims file is not an adequate basis for denying a claim or rejecting medical evidence to support the claim, particularly when that evidence is in the form of a Nexus Letter, Private Dbq, independent medical exam or opinion. So that's the first thing. That's the first and only thing I want to say about what you wrote there, is that the rejection of your positive evidence was improper. If it was based on, like you're saying, that because the private doctor didn't review your claims file. We got case law out there that says you can't really do that. You got to have some other reason as to the adequacy of the opinion for rejecting it.
Yeah, I was going to say exactly what Tamesha said. The reason they denied you is not a valid reason for denial. Mm-hmm. There's a significant case law that says that, the box that says I reviewed your C file need not be checked. To have the medical opinion at least weighed. So, you might, like, again, as we said in the previous cases, you might want to get a professional to look at that and give you some help and take it from there. All righty. Should I do a HLR, a supplemental with a private DBQ? That's a decision, both are valid options. It's a decision you have to make based on.
But only one of them allows you to provide additional evidence, and that's a supplemental. An HLR does not consider any additional evidence after the date of the claim, the date of the rating decision. So if you want to come with any new and relevant evidence to support your claim after you receive a rating decision, you have to do that as a supplemental, not as a request for a higher level review.
Right. Given what you stated, supplemental is the only option that if you want to submit new evidence, you would have to do a supplemental. And I was looking at some statistics from the VA's Monday morning report last week, which I posted in my main Facebook group. And it's something like somewhere upwards of 60% of higher level reviews are being denied right now. And I think a lot of that, a good portion, just in my opinion, and from what I see, of those HLRs that are being denied at this point is because it's veterans taking it on by themselves and trying to present new evidence or testimony when that can't be done in the HLR. It's just not the route that you should have taken. You know
yes.
what I mean?
Yes, exactly. And I just want to say, like, I do requests for higher level reviews when I get an unfavorable decision, but I will also tell you, I do a request for higher level review. I request an informal conference. Although I cannot submit additional evidence, I do provide written arguments as to why the prior decision is incorrect and what the correct decision should be. That is a skill. I think that and usually the people who conduct the HLR, like when I first started doing this, it just kind of threw me for a loop. They would call you and be like, hey, this is John from the VA, calling about your higher level review. You requested an informal conference. Are you available now? And they would just want you just like, yeah, you know, you're ready to go now. And I learned very quickly that you have got to go into a higher level review prepared with some degree of preparation. If you don't go into the informal conference prepared, you at least need to prepare as you go into the even submitting it, like what you put on that form. You know, I mean, I max my box out all the way. You know, I don't just put like appeals, back disability or anything like that, but I write stuff like direct service connection warranty, because back injury documented in service records. And then, you know, like I write some good detail in there so that when the rater gets what I wrote, they have some idea of where we're going, but also that speaks their language and it tells them, especially those, I mean, they're all trying to help you, but it's like, it tells them where we're going and it gives them what they need to give me to even consider just doing a different decision. And I think that if you look at those that are more successful, I'm willing to bet that it is because the person had a really good advocate to help them, or they had their file or some other things. And while you can't submit additional evidence, you can provide written arguments on a higher level review, and that is important, I think, to help really guide the rater as to what went on. Remember, I told you guys in the beginning, these claims files are thousands of pages long. So if I can point out where the service treatment record is about the back injury, what page it's on, how this record relates to the claim that was denied. It was direct, presumptive, secondary, an aggravation claim. When I can lay that out for them like that, I see tremendous difference in the outcome versus like when I started and they just like called on the phone and I started chatting it up with them right away. It's like, no, don't do that anymore.
Right. Tamesha made some very good points there about that. There's some of this takes skill when it comes to advocating for claims and doing the best work. Mm-hmm. Sometimes, I'm gonna say it once more, sometimes it's best to get a professional advocate on your side to work with you. But the thing that I've learned is that sometimes it's easy when somebody from the VA calls you on the phone. And in this instance, we're talking about a high level review, an informal conference decision review officer. It's easy to start wanting to tell your testimony, what's going on with the disability currently, and that type of thing. But the only thing that can be considered is the evidence that's of record already, and any written or verbal argument you might make. No new evidence. It's just no. That's what the law says. You cannot submit new evidence. So you have to, when you're evaluating whether you should do an HLR, consider what is of the record. Is the only thing there a negative CMP exam that the VA gave? Is there any positive or anything to combat that? Whether because your lay testimony on the phone with the higher level reviewer is not going to be enough. So the supplemental route or the BVA might be the best route.
And I'm going to tell you this, I want to just take it a step further. If you really don't know what's in the record, that is a huge, and let that be a signal to you to either one, request your claims file so that you can know what was in the record within that 1 year that you get to appeal your decision, or seek out some assistance from somebody who can look in your record. We took Carmella and we talk about this, but there are times now where I get the file, I can maybe go look at 5 things. Like they tell me what happened. I'm looking for 5 things and I'm like, oh, I know what this is. And it's a easier fix because I know what I'm looking for. I know how to course correct the error. And I also know if you tinker with this any longer, you're going to set yourself back way back, because once you get past that 1 year mark, now you need new and relevant evidence. You need new and relevant evidence to reopen a claim. You need clear and unmistakable error, and stuff like poor CMP exam, duty to assist doesn't really cut it. So if you don't really know, like if you assume something is in there, or that it says something, but you've never seen it and you've been at it for a while, take a step back. I know you want the claim done, but take some small steps to improve your position by first finding out what's actually in there and what was considered, what's in the record, and let that inform what will be your next move.
Yeah, one of your most important decisions is choosing the right venue for your owner denial for your appeal. What is the proper way or the most beneficial way for me to approach getting this corrected? You need to make that decision up front. You know your truth, you know your claim is valid, you know that the evidence should have been there, whether it was there or not. You know, you need to make sure that you have, if you don't have the tools, that you have somebody that can get them for you. So thank you for that, Tamesha. All righty. We're going to take just a couple more here. We've been here about an hour, so I wouldn't get to a whole lot of questions tonight, but we provided substantial answers on the questions we did take, and I'll try to answer some more of them when I get some time online somewhere that have been asked tonight, because we have a ton of questions, but we're going to take just maybe 2 or 3 more, and that's it. So this question says, so the VA was unable to locate my service treatment records. My claims are deferred and have been in decision phase for months prior to me uploading inpatient treatment records obtained from the National Archives. This is interesting.
Okay, so this is something I deal with very often. So prior to me starting my practice, I used to be an information law attorney. There are a number of things that you can do, and this kind of goes back to what I just said. The VA was unable to locate my service treatment records. They may have said that to that effect. You've provided your copy. Now what's next? And the answer is we don't know. And so if you've kind of gone around the bend, and if you've been around the bend on a claim and it sounds like this is something that's hung up, this may be a time for you to say, hey, let me take a step back and just let this play out. Or maybe this is a time for you to get with a rep, because if you have been at this for a while, now obtaining or associating service records with your claims file opens up some new opportunities for you in terms of earlier claims that you may have filed and that were denied. And so what you should consider is you went and got the records and got them to the VA. We don't know whether or not the VA ever got the records while this claim has been pending. So again, and I really wish that there was a better way. VA.gov, I think, is helpful, but I really wish that in a lot of ways, like VA had something where veterans could just see what's in the claims file. You know, it does. I do think it's a big disservice to a certain degree that you have to go hire somebody or retain somebody or third party. And not many people have that ability. Like, they may not even want to interact with another person or look for a person or know who to find or know who to hire. And it would be just so much more helpful if you could look and see what's in the file, because like I said, the records may be already there. What you've uploaded may be new to them. So we don't know.
Yes, but it's good that you were able to obtain the inpatient records, and we certainly wish you the best. Okay, so next question is pretty straightforward. I'm service connected for flat feet. Can I file back pain or a secondary? Certainly. If you feel like your back pain has resulted from your feet being flat, medical professional agrees, or you believe a COP examiner would agree, it's definitely worth pursuing. I certainly see the claim filed a lot. I've seen it service connected and denied in other instances, but it certainly is a valid, contention that it could happen. It's a possibility. So, just got 0% for rhinitis. What can I provide the VA to get this increase? I'm not sure why it was only 0. This is just like the question earlier asked about the 0% for migraines. There's a couple different routes you could take: supplemental with new evidence, HLR on the evidence of record, if you have something that shows it should have been rated higher, or you could go to the BVA, or you could put in a claim for increase. You have to evaluate that and decide what's the best route to take. Okay, I have a BVA hearing that has been expedited due to hardship. Will they also expedite my decision, Tamesha?
So I just recently had this with a terminal I think it depends. I'm going to tell you I had it in two different ways. In one instance, it was expedited due to previous administrative error that happened at the board. So their hearing was expedited, but the decision didn't come for nearly another 11 months. In my other case, where my veteran was terminally ill, the appeal was expedited and the decision was expedited as well. In those expedited cases, I think the board does an excellent job having, like, I don't know how they're able to do it. I think they have people who are not a part of the regular routine work, who work on these cases that have been advanced on the docket. But I think they do an excellent job on the AOD. So I'm going to assume financial hardship. Like I said, administrative error, advance on the docket, treated very differently from terminal illness, advanced age, or financial hardship. So you should see a decision sooner because it's been advanced. Carmella?
I agree. I agree with exactly what Tamesha said. It should happen. Very quickly, I see a couple other good ones that I do want to get to, so I'm going to maybe skip some questions here, but I will try to get back to them as I can. In a written form, does a civilian psychologist need to review the complete C file before he can write a proper nexus? We sort of answered this a little bit in a different question, but does he have to? The answer would be no, but to provide the best letter, it would be very beneficial. It's just a choice that needs to be made if you can get your hands on a C file in a timely manner, or when the deadline is for appeal, or and that type of thing. There's a lot of variables that need to be taken into consideration. But if you have maybe your service treatment records and you've kept a lot of records from the VA and stuff like that, he might be able to see the whole picture from what you have. But it's always best. The best letters are written when the medical professional can review the whole file. So that's my take. Okay, just a couple others here. Let's see. I saw some that I'd really like to answer. Here we go. Can a claim be rewritten, meaning that the claim is written as back pain, but there is nerve damage to support the initial back pain? So I'll answer this quickly. One of the interesting things about a back claim and a back C&P exam is that they ask about nerve damage when you claim the back. It's an ancillary issue, or called a downstream issue. A fancy term for it is inextricably intertwined with the back claim. So they always ask an examiner to comment on if there is what's called radiculopathy or nerve condition when they're examining the back. And if they were to write that there is nerve pain, the VA should, and the manual tells them to go ahead and write that issue. I always prefer to claim it explicitly too. If there's a sciatic or a nerve issue, or there's a lot of terms for nerve issues, different types of way to name it. But if you feel there's a nerve issue related to your back and you know that up front, go ahead and claim it. If you've already claimed it, back pain, and there's a nerve issue, be sure the examiner is aware, or you can go back and just file a claim for nerve pain secondary to the back too, or direct, or however you feel is best. But certainly you can clarify a claim or file a new claim for nerves while the back claim is pending. But even if you don't, they should still examine the nerve. Okay, just there was. Just a couple more. Let me see here. Deferral. Made my claim. Thank you all for all the nice comments. Y'all are so kind and so sweet. Okay, this is one that I did want to answer. My husband passed, because we have Tamesha here. My husband passed before all his claims are rated. So where do I go from here, Tamesha?
Okay, so I'm going through this right now. I just recently had a client to die. and the one I told you who was terminally ill. So he got a decision from the board. It was unfavorable. I appealed it to CAVIC. He died while his appeal was pending at CAVIC. And so the VA has a couple of processes in place. To do what's called a substitution of the claimant due to the death of the veteran. That's one thing. And then there's also what's known as an accrued benefits claim, meaning a claim for the benefits that would have become due to the veteran had you decided the claim during his lifetime. Those are the two things there. Now, let's kind of back up and say a couple of things here. Over the years, I've had a couple of different types of DIC claims. So it's not just that you send this stuff in, happens automatically. You need to be able to speak to or demonstrate that you were cohabitating with the veteran prior to their death. You also need to show that you were married and not divorced. Well, you need to show that you were married. Common law marriage is not... Common law marriage is only recognized in those states which recognize common law marriage. So for instance, if a surviving we call it a putative surviving spouse and veteran were living in North Carolina and claimed that they were common law husband and wife, the VA would not recognize that because that they were living as husband and wife in North Carolina. The VA would not recognize that as a valid marriage because common law marriage is not recognized under the laws of North Carolina. You have 1 year from the date of the veteran's death to get those petitions submitted. But I will say this, I think trying to do these things at the time or near the time that the veteran died can be a bit overwhelming. There are people and services that are available, particularly for those of a surviving spouse. You may be able to call it in. You may want to just put it to the side for a little while, take care of some other matters, but definitely write it on your calendar 1 year from the date of the veteran's death, and then give yourself like some reminders starting 60 days, 45, 30 days, 14 days, so that you've made sure that you've gotten these things in if they are a bit overwhelming to deal with now.
Thank you so much, Tamesha. So there are avenues that you can take, such substitution to get benefits that were maybe due your spouse. I'm so sorry for your loss, and I wish you well in that endeavor. If you need a professional's help, please retain a professional. There's a couple interesting things happening in VA world that I want to talk about right now. The first is that a lot of advocates were notified yesterday or the day before that the VA is piloting a program for right now for the next 30 days, or it started actually last month, that would give veterans the opportunity to download their rating decisions electronically. I was very excited to read that. I believe it's called eComs. So that's on. The VA is trying to get better ways for you to view a decision as soon as it's made. And that was very exciting to find out and hear. They're piloting a program for advocates to get notifications electronically. And that is happening now. And that would allow us not to get so much mail. I know a lot of you commented on my mail situation, so I wanted to keep you updated on that. And just generally, remember that we're still in the time of the COVID period and extension, which means there are no hard and fast deadlines right now. Ever since March 20th, 2020, you can essentially, if COVID affected you in some way, ask that a deadline be extended due to COVID-19 personal situation. Just write it on whatever claim form you're submitting, and they will apply it to your case, which means if you did not continuously pursue a claim, there was a gap or a deadline lapse, even an ITF, they will extend a intent to file, the manual says, or not the manual, but the COVID-19 guidance that the VA released says they will extend an intent to file that has expired if it's requested based on COVID-19. So use that to your advantage. Do not let, even if you sort of let a deadline lapse and it happened after your appeal period started after March 20th, 2019, you should use that so you get back paid all the way to the date that you filed the claim after March 20th, 2019, because the VA is allowing it. It's very simple. The guidance simply says if they request it, to give it. There's pretty much no other standard to meet. And so you should be using that. Use it to get earlier effective dates for your claims. I do think the only thing that it does say stipulation might be that it has to be requested up front on the claim application. I could be wrong about this. But I have yet to try to request one after I've already filed the claim. So I'm not very sure. I usually just put it on every form, that I'm sending in just in case. So, yeah, use that. But I'm so thankful that Attorney Tamesha Larbi was able to join us tonight. You've been so informative, and Tamesha, and you've helped. I know a lot of veterans. I see the comments here that said saying that you were very informative. So thank you. This will live on the internet, on YouTube and podcast. So a lot of people will see it later. And I'm so thankful that they've been exposed to your brilliance. Tell them how they can reach you in the future. And
okay, so I have a little website, just one little page, but I think all the things you need to know are right there on that one little page. But it's www.larbylegal.com. So it's my last name, LARB as in boy, I, legal.com. You can see my hours of operation, which are Monday through Thursday from 9:30 a.m. to 3:30 p.m. Eastern Standard Time. My office is closed on Friday, Saturday, and Sunday, and federal holidays. Office address, if you're in the Maryland area, which I saw that a couple of you were. My office is currently in Bowie, Maryland, but it will be relocating over the summer to New Carrollton. So we'll have greater accessibility to public transportation, Metrobus, MARC, Metro Train, and Amtrak. All are adjacent to my new office space. On the website, you can get my phone number, you can get my email address, but if you wanted to schedule a consultation, you can self-schedule those on the calendar as well. My office is staffed with a case manager, a legal assistant, and then we have 2 law clerks who also work in the office now to just kind of help things move along. And but just know that if you contact my office, it needs to be in relation to an actual rating decision that you want to appeal. I'm not able to really answer hypothetical questions. Usually people, when they're calling to consult, they're consulting about an actual decision that they have gotten. So when it comes to like initial claims, my office doesn't provide that work. Or provide representation for initial claims. We do in very limited circumstances, but generally I don't. But if you have received a rating decision from the regional office or from the Board of Veterans Appeals, and you'd like to discuss the rating decision and whatever your appellate options are, welcome you to visit the website and to also request a consultation. If, the technology just is not your thing, you can always call the office during office hours. Our case manager will get you on the schedule, or you can call us after hours and leave a message if we happen to be in different time zones. And you want to leave a message to have us call you back and request a consultation that way. Either way, whatever works for you generally works for us. We are we're military office. Everybody in my office has past and prior military experience. So we're always happy to help our veterans.
Awesome. So please reach out to Tamesha. Tamesha, if you're looking for representation, and she's a great qualified professional legal representation. I'm not accepting new clients probably until much later this year, until the end of the year. And so, there's a few other people that I referred to. Tamesha's one of them. And so,
and Carmella sends me like tough stuff, like really tough cases. And I'm just like, what happened? And it's not stuff that she has worked on that is usually like this veteran really needs a representative, and you can probably help him out. And I remember a relative of yours that came to my office, and I was like, girl, don't do this to me. Did you put him under like a microscope, right? When I have,
Yeah.
when I'm doing stuff for your family members. But it worked out really well. We took the case to CAVIC, got a JMR, and he hopefully is on his way to a different outcome for him. So yeah, I really enjoy what I do. I never languish. Well, I rarely languish in bed in the mornings, dreading going to work. Like, I actually get up and I leave my house every day, and I go to my office and I work in my office every day. Although today I'm here from home, but I go to my office every day because I can't. I really can't wait to get to work for my clients.
Yeah, I say all the time, this is passion work. I love what I do. It's very satisfying to win for a veteran and to see them finally overcome the hurdles that the VA obstacles.
Oh my God! Like,
for them, and so
it is, and for me, it's very significant because my clients tend to be like somewhere between like the 10-year of denials to like 20 or 30 years of denials. And when they come to me and I can finally tell them what the rating decision is, I mean, there are tears around. I don't know if your clients cry, but like, we cry and we celebrate, and we I just want to say this really quickly. So I recently had a client last year who I don't even know why he was getting denied. Like, his stuff was just off the top. I mean, it was there in the file. And he had some disabilities that were clearly documented in his service record, but earlier rating decisions said that it wasn't, there was no record of it. It wasn't service connected, none of that. And we, very aggressively pursued a revision. And like 2 days before Christmas, I get to call him and I get to tell him that, this thing has happened. And I will never forget him saying to me, like, oh my God, my kids are going to be so happy. The children had lost their mother. There was 4 of them. It was him by himself with his disability trying to raise these 4 kids. And he was like, I really had given up all hope that these people would do anything different after 30 years. And I'm like, here we are after 30 years doing something different. So I really enjoy that work. I really enjoy the people that I get to work for. It has great highs. It has, awful lows. Like I said, I had, just recently had a client to die and had just gotten him service connected after 30 something years. It just gotten him service connected the year prior, and he died less than 2 years later. He died. I mean, he was diagnosed with a terminal illness and died within 2 years of finally getting service connected. And so those are the lows, because that's always hard. But if I had to pick anything else to do, I'd be doing this.
That's great. That's great. So again, thank you all for joining us. Reach out to Tamesha if you can. I'll try to get back on and answer some of these questions, but both of us, I wanted to add that both of us can represent any veteran or dependent that needs it anywhere in the world. I serve globally. I represent a lot of foreign veterans. So just because we're based in me in North Carolina, Tamesha in Maryland, we're not limited to those states. So reach out if you need help. And, if I'm not doing intake, I know Tamesha is, but if I'm not, I'll try to point you in the right direction. So,
and also, if I feel like you have a case that's outside of my wheelhouse, that's my other thing. There's some things I feel like I'm exceptional at, and there are other things I'm like, I don't think I'm the best person for you, but let me tell you who I think can really help you. So even if I'm not the person, because like, for instance, I don't do pension work, but if I'm not the person, I'll definitely help find you somebody.
Yes, ma'am. So again, thank you all. I wish you the best in your claim. Take advantage of every benefit the VA has for you out there, because you serve this country well and you deserve it, and they promised it to you. You earned it. And so I'll be praying for you and your claims, and y'all take care. Have a wonderful night. Thank you again, Tamesha.
You're welcome. Bye-bye.
Bye.